Welcome to Securing Your Brand. Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative assets.
Hello and welcome to Securing Your Brand with Secure Mark Legal. I am here with the partners of the business, Melissa Jada and Holly McFall. Melissa, Holly, great to be with you guys again.
Hello.
It's great to be here again.
All right, so today we're going to talk about copyright infringement and what we should do, what someone should do if someone infringes on their copyright. So what are the first steps to take if you discover someone is infringing on your copyright?
So as a business owner, if you find that someone is using your image or selling your good on a website, you want to document it. You want to start by taking screenshots, saving the URL of where that is, as much information that you can document from the start. You want to document that you're using the image first, that you have the image of the good for sale first, or if it's artwork, if it's digital media artwork, or it's a painting that you're selling, those kinds of things. You want to make sure you're documenting your copyright registration. You want to make sure that you're documenting where that image is being used without your permission. If they don't have a license, you haven't given them permission to use it, and all of the URLs online of where you're finding that image. So documentation is definitely the first step.
How can you determine whether the infringement is actually significant enough to warrant legal action?
Well, it's a pretty subjective standard. So there's not a bright line, where it has to be a certain percentage of your thing that's been stolen. It just comes down to kind of common sense, I guess. You have to look at if you think it's actually disrupting your business, if you'd be able to show any damages if you were to, bring somebody to court, to sue them for the infringement. Has it harmed you, in any actual way? And is it likely to continue to harm you?
There's a lot of things that you can do as a business owner when you first find out that someone is using your image or using your good for sale, that before you even start legal action, you can start some of the takedown procedures and go through those procedures before you have to maybe involve an attorney directly. I don't know if I'd go as far as to say send a cease and desist letter on your own, but definitely some things that you can do on, make sure that you are preserving and protecting before you start legal action.
Okay. And what evidence is needed to prove the copyright infringement, and how should it be collected? You kind of mentioned about how, has it harmed you in some way and all that, but what all do you need to prove it?
So screenshots, of course, would be a good start. If we're talking about internet use, that's usually, one of the simplest things that you can do.
When you're screenshotting, you're copying the metadata, you're copying the URL, you're keeping track of the dates in which you went ahead and found that information online. If it's a social media post, if it's through that, and what outlet, how it's being presented. Is it on social media? Is it a website? Is it a shopping cart like Amazon or Etsy or something else like that? Or is it someone's actual website? And then from there, you can start the DMC takedown and go through the procedure.
What are the procedures for takedown then?
So it relatively is kind of the same depending upon whether it's posted, a web host, if it's a shopping cart site, if it's social media. You need to go through, and every website, every shopping cart, social media, all now has these procedures available for you to see. There are companies out there that will do the DMC or the takedowns for you, but these are things that some business owners can start on their own if they want. They can contact the host, the web host, and ask them for their DMC procedures or their takedown procedures. And it may be sending an email with the proof, the dates, the showing that you originally own it. It may be a form. And typically, once you send the email or you submit the form, that owner, so the web host owner, Google or Amazon or whatever social media platform it is, will go through their procedure and review it. They will contact the alleged infringer, not be rude, and they will say, this doesn't belong to you. This is not yours. We've had someone complain that you don't own this. They will stop it and take it down, and they have a chance to reply. Now, the company, the infringer, has the ability to take it down and say, oops, my bad. Or maybe, nope, I really wasn't infringing. I own it, but they take it down anyways because they know they're infringing, but they don't want to get in trouble for it. And this way, you're not going through the actual legal procedures to stop it. You're taking it down, getting it stopped. It is kind of a whack-a-mole procedure. You've got to do it every time it comes up, but it does stop the companies that are infringing pretty quickly. And that's the purpose of the Digital Millennial Copyright Act, is to be able to stop these infringers pretty quickly and say, this is my work. You don't have the right to go ahead and show it.
What happens if there's a fight? If people are like, no, I own this, there's a battle, like what happens? Does that happen often?
That's going to be when you want to contact an attorney. That's when you're going to want to go the legal route and see, okay, this is infecting my business. They are taking sales away from me. They are using my image. And that attorney will typically start with a cease and desist letter. Let's say it's a copyright infringement. I own the photograph. They use the photograph. They're going to say, it's registered. I have a trademark. I presume damages. The licensing to purchase that was X dollars. And they're going to go ahead and send a cease and desist letter and make a demand for payment. They reject that. They come back and they, answer the cease and desist letter. And then it really is, between you and your legal counsel, depending on how far you want to go. Do you want to sue? Is it a registered trademark? Now you have the right to sue in federal court. Do you want to seek statutory damages? Or do your damages exceed the statutory amount? They really are affecting your business and they're causing you a lot of damage. That's all legal determination at that point.
Okay. And then if you get that letter in the mail, then it says, you got to take this down, you're infringing, and you owe us this X amount of dollars. And let's say the people just ignore the letter, but they take the image down, but they ignore the letter. Is it kind of up to the company if they want to pursue that money too, or how does that kind of work?
Yes. So taking something down does not absolve you of the infringement that you've already committed prior to that point.
Okay.
So yes, that would then be the actual copyright owner's choice at that point. Are they satisfied with simply the image being gone and, assuming that it's not going to go right back up again?
Right.
Or do they believe that they have the right to significant damages? Melissa mentioned statutory damages. So what that means is that even if you have a registered copyright, you go into federal court and sue somebody for infringement, you have the right to go after damages for a dollar amount, even without proving that you have suffered damages in that dollar amount. So a good example I like to use is a photographer that posts photos on their Facebook page to advertise their business, to show, that these are some of the works that I've done. This is my style. And somebody steals one of those photographs and starts using it on their business page. Now, this photographer is probably not trying to sell that image on their Facebook page. So they can't prove that they've lost X amount of dollars. Like if they were trying to sell it for $100 each, and it was a 24-hour period, and they have sold like 5, in a typical 24-hour period, that would be an actual damages of like $500. But in a case where you're not selling that image, there is no actual hard dollar amount that they've lost by this other photographer stealing their photo. Mm-hmm. So they can ask the judge for statutory damages, which means the judge can assign a dollar amount per infringement, regardless of any proof of any loss, any financial loss. So that can be a very significant advantage and a significant factor that would go into that determination about whether or not to go any further with this infringement or to just let it go because now it's been taken down. If they think that they can recover a significant amount in statutory damages by filing in federal court, and they want to put forth, that effort and that expense of hiring an attorney and going through that legal process, that would help them make that determination.
What role does mediation or settlement play in resolving copyright disputes, and how can it be approached with sort of a mindful attitude?
I was a corporate litigation attorney and did all kinds of litigation prior to becoming a trademark and copyright attorney. And I get to now build businesses, which is way more fun. So we come from the mindset of we want to help build and connect bridges. So we are always willing to try to mediate and resolve issues. Maybe it's not the right position for every case, but in the majority of the cases, we're going to send a cease and desist letter with the idea that we can either build a bridge and we can work together, we can resolve issues. Yeah, you may have to pay some money, but we can resolve issues and continue to be two businesses that are working and thriving, maybe within the same zone, but not either within the same name or the same products or the same, infringing on my goods and my ability to sell my business. But we attack everything from a very mindful kind of perspective of building businesses. At the end of the day, we are all entrepreneurs and we're all trying to continue to build our businesses. Maybe it wasn't intentional, but if you're going to continue doing it, you're going to continue causing my clients problems, then I might not be so nice the second time.
Sometimes when you sit down to have these conversations and really better understand the other side in their business, sometimes, our clients come to the realization that maybe it's not as much of a threat as I thought it was. Maybe we could possibly work together to both of our mutual benefits. And it can really bring the level of aggravation and anger down. And, maybe, if you see that they weren't doing it on purpose, this wasn't an attack against your business, kind of reshape what the issue really is and try to come to a resolution much quicker than you would reach if you filed the lawsuit. You're talking multiple years oftentimes before there's a resolution. And there's a lot of value, a lot of dollar amount that you can attach to that time that then everyone is being held back from furthering their business and making money.
What are the potential consequences of pursuing a copyright infringement claim, kind of like from a legal perspective and then maybe from a public perspective too?
Well, from the legal perspective, anytime you go to a court and you're in front of a judge, it's uncertainty. Yeah. You never know really what's going to happen in court, if a judge is going to rule for or against you, if there's a jury involved, who are those people that are chosen for the jury? What are their perspectives? Are they having a bad day that day? There are just so many different factors that just lend to great uncertainty when you're going into a legal case.
One of the considerations before we send out a cease and desist letter. So maybe you've gone the route and done a takedown, didn't happen, didn't get taken down. Maybe they provide you some evidence that they may have or use the same image first, or whatever it may be, sold the same product or had the same trademark before you, is a declaration action. So a DEC action can happen. If you send a cease and desist action, the person you send, the company you send the cease and desist letter to, they can start a proceeding in district court. And maybe you didn't want to go right to court. In consideration of that cease and desist letter is, can this person come back at me? Have I done something? We want to take and do all of our due diligence even before sending the cease and desist letter.
So I have a big question with a big buzzword for you. AI. How has that changed things? I mean, because you brought up art earlier, and I mean, obviously that's a big deal right now. And with that, is that kind of taking your whole business and just sort of flipped it on its head and made everything all crazy, or does it all kind of fall in the same way?
Sometimes, it has definitely played a role in copyrights. As we know, as it stands at the recording of this podcast, you cannot record 100% AI generated work because a computer is not a human author. That is the current ruling as we're sitting here today. But what about if you went ahead and used my research material or my website as the prompt for your website in AI? Did you steal my ideas? Did you steal my works? What if those languages are similar? So using AI, it's a tool. And if we look at it as a tool to help us proceed, research, outline, yes, great. But if you use it for more than a tool, then you may be actually causing a problem and infringing on someone else's copyright or trademark.
Have you guys had many cases involving AI since kind of ChatGPT blew up?
Not really. A lot of the artwork that's created by AI is, original artwork. Now they're not going to be able to, get a copyright on that artwork, but they may be able to use it on their social media or website in that regard. So it normally is original. There is definitely some suits out there in regards to, you want to do it like a Picasso. You want to do it like a certain artist. You want to create work along those lines. And does that involve copyright infringement? And we're waiting to see what happens with that litigation. That has not yet been decided. But if you're just using AI as a tool to generate an image, generate a text, and then you're going in as a human and creating it and tweaking it and making sure it's proper, then chances are you'll be okay. But we have not seen a lot of, lawsuits related to AI at the moment. And those laws are changing. This is going to be an ever-changing area of law for a while now. And see how technology advances, just as it has in our past, changes our law in the future.
Yeah, that's a very good point. It's going to be interesting to see how the regulation comes down. Can you share a recent case of copyright infringement and discuss the outcome?
One of the sadder cases that we've seen and come across is that where someone had their marketing company use and create their social media, created their website, or they had a website, web host company create their website, and they maybe did it overseas and they're not so conscious about copyright. And they went ahead and put all of the images on that website were copyrighted, and the majority from the same source. And so when they got the cease and desist letter, they got the takedown letter, it was a lot. And it was an entrepreneur and they were just starting out. And for them, it was a total end game for their business. They had to stop. It didn't have a happy ending. But it is a good word of caution that if you are not putting out your images, if you're not creating your images and you're using a third party to create your images and create your content, that you're making sure you're getting an image log, you know where those images are coming from, and you're making sure that you know that those original arts, works of art, or they have licensing purchases and you have a copy of those license agreements. So that way you know what that picture is and where it came from in the source before you have it put up.
Yeah, it definitely comes as a surprise to most business owners that find themselves in that situation, that it is your ultimate responsibility as the business owner, regardless of whether you're the one that actually put that up on your website. You're responsible for the vendors and employees that you hire to do those things. So it's your responsibility, like Melissa said, to insist on them keeping those image logs and sending proof to you whenever they download an image from the internet or whatever, so that you have it in your records, whether there was a license purchased to use that photograph, because keeping in mind that a lawsuit or a cease and desist can come years down the line, maybe long after that web designer is gone, maybe they're no longer in business and you can't even get that information anymore. It's important to have it in your back pocket just in case something like that happens.
Is there any situation where you can kind of go after the web designer or the company, or is there any recourse in that scenario, or not really?
Our favorite legal answer, it depends. What does your contract say? Were you indemnified? Can you hold them responsible in that contract? It depends upon what your contract says. But the majority of the time, no, you can't. And you're the business owner, you're responsible. But that goes along the same lines that if you are the one creating the work and you are the one putting the work out there, you want to make sure your work is protected too. So we were talking about in the beginning of this, finding someone who's infringing on my work. You want to make sure that you're setting up your watch services, you're setting up your alerts, you're scouring the web, just like AI is scouring the web looking for someone infringing, that you're looking for someone infringing on your work, that you're policing your brand, your images, your works, and that way you're protecting it all the way through. There are websites and companies that you can use to set up alerts and set up watch services to make sure that your work is protected.
All right. Well, I think that if anybody takes anything away from this episode, it's image log. Image log, people. Don't forget those words. Well, all right. Well, thanks for tuning in to Securing Your Brand with Melissa Jada and Holly McFall. Don't forget to like and subscribe to the channel. And thank you very much for tuning in. And I hope you got some stuff out of it. So Melissa, Holly, great to see you guys. Looking forward to the next one.
It was a great episode. Looking forward to it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.